Another approach is to identify types of speech that the court has determined not to be protected by the First Amendment. Fighting words, speech that would provoke an otherwise reasonable person to engage in a physical altercation with the speaker, is one such area. The Supreme Court articulated the fighting words doctrine in the 1942 case, Chaplinsky v. New Hampshire. Walter Chaplinsky, a Jehovah's Witness, had called a New Hampshire town marshal who was attempting to prevent him from preaching, quote, a goddamn racketeer, unquote, and stated that, quote, the whole government of Rochester are fascists or agents of fascists, unquote. Under New Hampshire's offensive conduct law, it was illegal for anyone to address another person with any offensive, derisive, or annoying word to anyone who was lawfully in the street or public place, or to call to him by an offensive or derisive name. The court upheld the arrest, saying, quote, there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those by which their very utterance inflict injury or tend to incite an immediate breach of the peace. It has been well observed that such utterances are no essential part of any exposition of ideas, and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality, unquote. The court further stated that resort to epithets or personal abuse is not in any proper sense a communication of information or opinion safeguarded by the Constitution, and defined the word offensive in this context not in terms of what a particular addressee thinks, quote, but what men of common intelligence would understand would be words likely to cause an average addressee to fight, unquote.